Good evening. Welcome to the Marion Minor Cook Athenaeum. I'm A. Vasquez, one of your fellows for this year. The United States Supreme Court is currently examining two landmark cases involving affirmative action in college admissions, one involving Harvard University and the other the University of North Carolina. The Supreme Court's decision in these cases could impact the legality of affirmative action programs and the use of race in admissions decisions, and may have significant implications for the makeup of college student bodies in the years to come. The far-reaching implications for colleges and universities across the country have many anxiously awaiting the court's decision. Joining us tonight is economist and law professor Richard Sonder to provide his insights and analysis on the potential outcomes for the future of higher education in the United States. Sonder has been studying and writing about affirmative action diversity in higher education for 2 decades. He is the author of the book, Mismatch, How Affirmative Action Hurts Students It's Intended to Help and Why Universities Won't Admit It, which challenges the conventional wisdom that affirmative action is a necessary tool for promoting diversity on college campuses. He has also written extensively on the impact of affirmative action on law schools and the legal profession. Professor Sonder has provided his perspective on various court cases, most notably the aforementioned Harvard UNC cases, in which he served as an unpaid informal advisor to the plaintiffs and submitted an amicus curiae in their support. He has been a vocal critic of the use of race in college admissions, arguing that it often leads to the admission of students who are ill-prepared for the academic challenges they will face. Before welcoming our speaker, we ask that cell phones be silenced and put away, and remind the audience that video and audio recordings are strictly prohibited. At the end of tonight's presentation, we will proceed with dinner and later audience Q&A. Thank you for accommodating our flipped app. With that in mind, please welcome to the app, Professor Richard Sonder.
So am I live now? Okay, sounds like you can hear me. I can hear me. Thank you all for coming. Thank you to the Ath folks for inviting me. I gave a talk here about 10 years ago, and lots happened since then. So almost all my slides are newer. I'm still, unfortunately, rooted in sort of late 20th century PowerPoint technology. So you won't see any dazzling visual effects, but I think the substance will be good. And I'm looking forward to the Q&A. So I'm going to talk about, first give you kind of an examination of the Supreme Court cases themselves and how they might turn out. I've been pretty closely involved with these cases, not in a formal way, but informally, really since when they were just a gleam in the eye of people who eventually became the plaintiffs. So we'll talk about that. Then I'm going to talk about my arguments about how affirmative action works, and then explore sort of good and bad scenarios that could follow whatever the Supreme Court decides. All right, so we'll start with the cases. So there have been several affirmative action cases before, and I think you can still see me if I'm down here, right? Most likely to fall off. We had the Bakke case in 1978. We had the Grutter and Gratz cases in 2003. We had the Fisher cases in 2013 and 2016. So the Supreme Court has spent a lot of time thinking about race and the use of race in higher education admissions. These cases are different. The ones before the Supreme Court now are different than we've had before. Most obviously because the ideological makeup of the court is less friendly. Although, interestingly, in each of the sort of prior episodes of the Supreme Court, there was a nominal 5-4 conservative majority in the court. And in each of those prior decisions, someone who was sort of expected to be skeptical about affirmative action ended up voting to support it. And in each of those earlier decisions, the court kind of tried to fashion a compromise. They sort of said, we want to have restrictions on what universities can do, but we're going to leave a window for flexibility. And the general pattern, I think, is the university sort of jumped through that window and interpreted it very aggressively. Harvard is the first defendant in these cases that's not a public university. All the earlier cases involve generally state flagship universities. They're not covered by the 14th Amendment, which has been the main theory that's driven past affirmative action cases. They are covered by the Civil Rights Act of 1964, which says that if you receive government funding, you can't discriminate based on race. Something that I contributed to these cases was the idea that we should have data-driven cases. So the earlier cases tended to focus not so much on exactly what the universities did, but on the general principle of whether race consciousness was permissible. I thought it would be relevant to try to understand exactly how large the preferences were, how they worked, what was the context in which these were operating. And I also argue that it would be good to have a case that featured discrimination against Asian Americans, because we tend to think of affirmative action as sort of whites versus minorities. And a lot of what's going on now in higher education is Asian Americans being a disfavored minority and blacks and Hispanics being favored minorities. Oops. Here we go. Okay. So with all the empirical evidence that was generated in the case, in the Harvard case, the experts involved produced pretty comprehensive reports. These findings that I'm describing are findings, I'm gonna give some findings from both sides, but my view is that the plaintiff's expert did a much more balanced and thorough job of looking at the evidence impartially. And he concluded that the penalty for Asian American applicants was about 25 to 30% relative to Anglos. Something that I found in looking at the data myself, although this wasn't part of the official case, was that Harvard had different types of racial and ethnic penalties that were very specific. So when we use the term Asian American, we're actually referring to a pretty disparate group. I mean, Asia, after all, is about half the world's population. If you look at Harvard admissions data for American-born people applying to Harvard, you find that there's one size penalty that's applied to subcontinent Asians, people from India or Pakistani, whose parents are from there, another for Korean Americans, another for Chinese Americans, another for Japanese Americans. So it's very, very sort of stratified and targeted levels of preferences and discrimination. A lot of what was done in the Harvard situation, less so in the UNC, was done through personal ratings, which I'm going to come back to and talk in a minute. Important issues, if you sort of look at what the plaintiffs were contending, they were saying, well, Asian American discrimination is more clearly unconstitutional than discrimination against whites. Previous court cases have said that if you use preferences, you can't racially balance. In other words, you can't try to come up with a particular combination of races. You can sort of use a general minority preference and a general majority penalty, but you can't sort of tailor in the way I'm describing. You can't use quotas. And they also argued that Harvard was neglecting class. They were not paying attention or much attention to socioeconomic status. And that violated a Supreme Court rule that said preferences have to be narrowly tailored. If you can do something that doesn't use race but produces diversity, you have to favor that sort of mechanism over the explicit use of race. What the cases didn't get into was any of the research that I've done. So all of these cases, Harvard and UNC cases, entirely focus on what happens in the admissions level. It doesn't talk at all about what happens after admissions. So a lot of my argument, some stuff I'll present later, is the idea that preferences can be counterproductive, that they end up reducing graduation rates or the success of students going into STEM majors and things like that. None of that was in either of these cases. Okay, probably this is the most damaging thing that came out in discovery in terms of an internal document that existed at Harvard. This is a report that was done by the Office of Institutional Research in 2013. And what they analyzed, so this was a year and a half before the lawsuit was filed. And it was an internal analysis of kind of how does race change as we introduce various analytic factors in the admissions process. And you know what it basically shows is that Asians do very well when you just focus on academics. African Americans do poorly. As you add in legacy and athletic preferences, that changes some. You add in the personal ratings that we're going to talk about, extracurriculars, it changes more. When you add in demographics, which is basically the consideration of race and gender, that's when you get the real sort of racial rebalancing. So this is what made it really hard for Harvard to say, oh, no, we're not really paying attention to race. Okay. So Harvard has a system where they give people ratings on various dimensions. If you get a 1 rating, you're considered a superstar. 2 rating, you're very strong. 3 is pretty good. 4 or higher, maybe not admissible. So if you look at the academic ratings, you can see there's a pretty clear pattern. Asian Americans do really well. This is sort of a per capita rating, right? What's the probability that you're going to be in one of these categories? So Asian Americans do really well, then whites, then Hispanics, and then blacks. If you just look at those 1 or 2 ratings, right? If you look at Harvard's personal ratings, and that was sort of an assessment of what are the personal qualities of this person? What are they likely to contribute in terms of leadership skills? How strong is their extracurricular background? Then you find that personal ratings, when you control for academic strength, tended to be very highly associated with race. So black students got the highest personal ratings, then Hispanics, then whites, then Asian Americans. So the thing to notice about this is that the overall personal ratings, if you control for academic status, was just the inverse of the academic ratings, right? If you added these 2 things together, you would sort of get a racial balance. So the question is, was that legitimate, or was Harvard sort of deliberately skewing the results? Well, one thing the plaintiffs presented that suggested it was skewed is that these admissions office personal ratings were very different from ratings that were given by alumni. Harvard has this big network of alumni. They send them out to interview applicants, and they're asked by the admissions office to submit ratings. The plaintiffs were able to get a copy of those ratings. And that tended to show that there wasn't much difference in ratings by race once you controlled for academic status. So that makes the internal ratings look kind of suspicious. Even more suspicious is when you compare it to data from another institution like UCLA, which was under a requirement in the early 2000s, well, it still is formally, to be race neutral. They have personal ratings in their process too. And what those show is, again, not very much difference across races once you control for academic inputs. So all of this suggested that what Harvard was doing was really kind of suspicious, that they were offsetting the Asian academic advantage with a personal rating disadvantage and sort of what Harvard called a racial tip. In terms of the quota issue, the plaintiffs analyzed the admissions and they found that over 3 admission cycles at Harvard, if you just looked at domestic admissions, the proportion of African Americans who were admitted was essentially identical to the proportion of everyone else who was admitted. So close that the difference was just like 1 person. So in other words, you could predict if you took the 2017 data and then you just looked at the 2018 and 2019 data before the admissions decisions were made, you could essentially predict exactly how many blacks would be admitted by Harvard. Well, that looks an awful lot like a quota. So this is a chart that was prepared by David Card. He's an economist at Berkeley. He's won the Nobel Prize. He was the university's economic expert. He was doing their analysis. And this was one of his key charts. And he argued that if you did a series of regressions and you try to predict admissions outcomes based on these various factors, a lot of them seem to be given heavy weight, and they were. But if you use race by itself to predict admissions, the effect was essentially 0. Now, it was my argument that actually proved exactly the opposite, that this actually proves that Harvard was engaged in racial balancing. Because we know, you saw in these other charts, that things like personal ratings, academic ratings, varied tremendously by race. There were clearly differences in qualifications across different racial groups. When you do a regression and you're just using race to predict, what this coefficient actually means is that you're admitting exactly the same percentage of each group. That's why race falls out of the equation. So it's exactly consistent with this, where you get these matching percentages, right? So this I consider to be smoking gun evidence of racial balancing. If we try to come up with a way to conceptualize the size of preferences overall, a way of doing it is to sort of figure out who's the median student who's admitted at Harvard or UNC, and how do their chances of admission change if all you change about them is their race. So for Harvard, that's 25% if you're Asian American, and it gradually increases, it's 93% if you're black. At UNC, for out-of-state applicants, it's, what do I do with the Asian Americans? I think it's about 10% for Asian Americans, and also gradually goes up for these other groups. So, you know, how large you consider that preference is sort of a matter of perspective, but it clearly makes a pretty significant difference. Arsenio looked at some particular subsets of the UNC population and found much larger preferences if you looked at particular groups. So if you had a parent who went to college, characteristics that produce a 10% admissions probability for Asian Americans produce a 97 to 99% admissions probability for blacks. He was also able to look at how important socioeconomic status was, and found it was much less important than race in both institutions. The other thing that was troubling was that at Harvard, socioeconomic status really wasn't counted at all for black and Hispanic applicants. It was counted for whites and Asians, but it sort of fell out for blacks and Hispanics. Partly because I think Harvard was trying to minimize what I'm going to describe as mismatch. They didn't want to aggravate credential disparities between groups. But what that meant was that black and Hispanic students who were admitted by Harvard tended to come from relatively privileged backgrounds. Legacy preferences are an interesting story. I think most of you know that the Ivy League colleges give legacy preferences. They also give preferences for athletes. What's striking is that 20 years ago, those preferences were probably about a quarter the size of racial preferences. But they've been steadily growing. Because Harvard, for example, essentially promises its alumni boards that it's going to set aside about a quarter of the class for legacies, for example. But that quarter has been increasingly competing with a ballooning pool of overall applicants. I mean, the number of people applying to Harvard is something like tripled in the last 20 years. So that means that Harvard has to keep giving larger and larger preferences to maintain its legacy pool. So legacy preferences at Harvard are now, really now sort of overlap in size with racial preferences. It's important to note, too, that legacy preferences are not exclusively or even predominantly for whites at Harvard anymore, because Harvard has had affirmative action for many decades. Therefore, the legacy pool is kind of diverse as well. Alan Morrison is a famous old school liberal who helped found Public Citizen with Ralph Nader back in the late 1960s and early 1970s. And, he adheres to most liberal causes, but is kind of like me in that he's somebody who's left of center, but he's skeptical about some parts of affirmative action. And he decided to write a brief criticizing legally the use of legacy preferences. And his argument was that since universities that use race are required by the Supreme Court to engage in narrow tailoring, then Harvard could increase its diversity without using racial preferences, by getting rid of legacy preferences. So it's an interesting backdoor argument to attack legacies. He wrote this, and then he sort of paused because he thought, well, if I file that under my own name, I'm going to be hated by all my colleagues. So I want to find somebody who can be sort of the nominal filer. I'll still sign on as counsel for that person. So he called up a few people, including me, and said, can you help me find someone to be the nominal filer of this brief? And so I called up some conservative organizations I knew, and they said, well, we don't want to be on a brief by Alan Morrison. And then I called up some liberal organizations I knew, and they said, well, we don't want to be on a brief that's attacking affirmative action. So finally, I came up with the idea of asking my wife. And she said yes. And Alan Morrison was very, very happy to have her do it because she's a dean at Caltech, and Caltech got rid of legacy preferences 20 years ago. So it all worked out. But it was kind of, we had interesting dinner table conversations when my wife's brief was getting more attention than mine. Okay, so I've presented a lot of stuff that's kind of critical of what the UNC and Harvard are doing. Let me give some of their arguments. The Ivy League in general has paid more attention to socioeconomic issues over the last 20 years. So at Harvard, for example, you basically get a free ride if your family income's under $100,000. There are significantly more Pell students in the Ivy League than there were 20 years ago. So there has been progress independent of this lawsuit in that direction. It's also the case that there's not really evidence, I think, that either UNC or Harvard have it out for any particular group. They are really just saying, we're going to take the whole applicant pool, and then we want to admit exactly the same percentage of every group in the applicant pool, as I said before. So that's not really singling anyone out. But on the other hand, that's essentially what Harvard did 100 years ago with Jews. They said, you know, we have a problem. We have too many Jews getting into Harvard. They're doing too well on the entrance examination. So they cut the Jewish population from about 25 to 30% in 1920 to a quota of 15%. And I think that accurately describes what they're doing now. I was at the oral argument on October 31st. So a fun fact about the Supreme Court is that the last time there was a big oral argument on affirmative action was on April Fool's Day. And this time it was on Halloween. So there's some dynamic going on there. I'm not sure what's driving it. The October 31st argument, I think, may have been the longest oral argument in Supreme Court history, because when COVID hit, Supreme Court got rid of a long tradition of limiting oral arguments to an hour, because these arguments are there's very intense back and forth. And on Zoom, it just didn't work. So they sort of got rid of the time limit. And they kept that when they came back after COVID. They decided they kind of liked it. And then the argument was doubled in length because Justice Jackson, the newest justice, was a former overseer at Harvard. So she said, I'm kind of conflicted out of the Harvard case. Can we separate these cases? So they had two sets of oral arguments. And it was really interesting. One of the things that was striking was the degree to which the justices didn't focus on the numbers, which, you know, I was sitting next to the plaintiff's expert, and we were sort of moaning that there wasn't more discussion of the statistics that came out. Some of the stuff that I've been going over. What they focused on in general was kind of broader logical problems with the affirmative action regime. So the court has repeatedly said preferences are okay if they're temporary. And many of the justices said, well, you know, it's now 2023. We've been doing this for 50 years. University of Michigan said in 2003 they just need a little bit more time to get rid of preferences, but the size of preferences hasn't really gone down over time. Many of the justices asked the two university counsel to specify what's the level of diversity that you're trying to seek? What's your goal here? And the counsel consistently dodged that question because they don't want to suggest that they're pursuing any particular quota. But that also means that they can't really articulate what's the goal and what's the exact harm of not using the racial preferences. They dodged questions about, differentially treating Asian Americans, the analogy to Harvard's Jewish quota. John Roberts asked, how do you define someone's race? How do you determine whether someone is of race A or race B? And Harvard's counsel says, well, we let people self-identify. That's a little bit problematic because the largest growing population in the United States, in terms of a section of our demography, are multiracial people. So if you're sort of categorizing people into one of these, cabineting them into one of these categories, then that creates a bit of a contradiction. One of the arguments that liberals raised, I think this was raised by Justice Jackson, was whether or not if the court got rid of preferences, you could consider someone's historical background as well as their parental background. And I think one of the challenges that will happen if the Supreme Court does rule out preferences will be dealing with this type of question and sort of figuring out, well, how do we distinguish principled different distinctions that are made based on someone's background from something that looks statistically like a systematic pattern of discrimination. So I think there are three different ways that the court can come out on this decision. The conciliatory approach is to sort of tweak what the court's done in the past. In other words, come out with another decision that's similar to Bakke and Grutter and Fisher, but try to be a little bit more specific. Try to pin down more narrowly what universities can do. My guess is that's the least likely of the three outcomes, because I think a majority of the court has decided that old approach doesn't work. The aggressive approach would be to say preferences are just unconstitutional. We shouldn't allow any distinctions to be made on the basis of race. That would be a pretty dramatic step, but probably is the most likely step. The intermediate approach, with which Justice Gorsuch was pushing in the arguments, is to just hold that the preferences violate Title VI. If you did that, you'd be, I think, more soundly relying on statutory language and congressional debate, because it is pretty clear when Title VI was passed in 1964 that people were, congressmen and senators were concerned about the possibility of racial quotas. And there was specific discussion that this language would prevent that. Hubert Humphrey, a famous liberal from the time, memorably said on the floor of Congress, if this law is ever used to justify quotas, I'll eat the bill. Well, he died before the first litigation came to the court, so he was never actually in a position where he had to eat the bill. The Title VI approach would allow the court to create a framework where Congress could create racial preferences. They would just have to amend Title VI. They wouldn't be completely off the board. Okay. Now let me talk a little bit about how racial preferences work. The article that sort of got me into this issue was called A Systemic Analysis of Affirmative Action in Law Schools. And essentially, I was able to get data on a large cross-section of law schools, about 90% of all the law schools in the country. And what I found was something very puzzling. That in most ways, when you controlled for the information that you had about students in law school, you didn't find any racial differences in bar passage. In other words, when you controlled for law school grades and entering credentials, blacks, Hispanics, whites, Asians, they all did pretty much the same on bar exams. But if you just controlled for entering credentials, there was a big racial gap. And what seemed to be going on was that large preferences were putting Black and Hispanic students into schools where they were at a significant competitive disadvantage. They were very concentrated in the bottom of the class in terms of GPA. And then the GPA was predicting significant problems in the bar. So systemically, what seemed to be happening is that we were moving Black and Hispanic students up to more competitive schools where they were likely to learn less than if they'd gone to a less competitive school and been closer to the middle of the class. But this was all on, it was all being inferred from somewhat indirect data. I mean, all the patterns I'm describing existed, but we couldn't directly measure individual levels of mismatch because the data didn't allow that. The data had actually been designed not to allow that, to keep any individual school from getting into trouble. Some things that were pretty clear even from the early analysis, and which other scholars who have done work on this have confirmed, is that mismatch is not about race. In other words, mismatch affects legacies or athletes or minorities. Anyone who receives a large preference seems to be subject to the same type of effect. Affirmative action is very different from large preferences because if you eliminate the use of racial preferences, you still have many, many tools, some of which I'm going to talk about later, to try to foster diversity. Outreach programs, changing admissions criteria. All those things are part of affirmative action, but they're different from preferences and they don't lead to things like mismatch. Almost all elite universities still give relatively little weight to socioeconomic disadvantage. The gap between racial preferences and socioeconomic preferences at law schools, for example, is about 20 or 30 to 1. Mismatch can take a few different forms. I'm not going to go too much into that, but social mismatch, for example, would be an effect where if you have students being admitted by race with very different credentials, that can lead to less social interaction at the college. It can sort of produce counterproductive effects for the goal of trying to create diverse friendship networks and diverse learning experiences. So here's an example of mismatch data that we now have where we can control for what's going on at an individual school. So I've got 3 different schools here. A pretty elite school with a median LSAT of 164. LSATs go from 120 to 180. A moderately elite school and a non-elite school. And what you find is that so the median here is 152. If you take a student who has that 152 and they go to the elite school, their first-time bar passage rate is 22%. Students with that score who go to the medium school have a 51% bar passage rate and 79% if they go to the school where their credential is the same as the average student. Okay? It's hard to imagine any explanation other than mismatch that could account for that sort of disparity. So I said mismatch is not a racial effect. The reason why these effects tend to correlate so strongly with race is because, especially at law school, preferences are really driven by race. So I talked about at Harvard, you've got large legacy preferences and large athletic preferences. Those don't really operate in medical schools or law schools. So African Americans are about 40 times as likely as whites to receive the largest, most sort of threatening, mismatch-inducing type preference. So these are just showing the ratios of students of different races with different degrees of departing from the middle of the class. So if you're in category 0, that means that your credentials are at or above the class average that you're part of. And then 1 through 7, you gradually get into larger and larger preferences. So here's another example of mismatch that again is using specific data where you can measure how far someone is from the middle of their class. And this is looking at science mismatch. This is a phenomenon where students go to a college, they want to be a chemist, they major in chemistry, and then they often switch out of chemistry or they don't graduate. Okay? What we find is that your odds of doing that are directly correlated with sort of your level of mismatch to the class. So if you come in with a large mismatch, then your odds are about half as large of actually completing that major as if you come in without any mismatch. 2 other things about this chart worth pointing out are that this is the Asian American line, this is the white line and the Black and Hispanic line. This is what I mean when I say For most students, there's no racial effect in mismatch. The Asian American then, I think, is a phenomenon of many of the Asian Americans in this study being relatively recent immigrants. And therefore, their performance sort of looked like it was exceptionally high, but that's because they had English scores coming in that were exceptionally low. The other thing that's important here is that here, you're actually getting kind of an extra benefit from being overmatched, having higher credentials than your classmates. We don't see that in most of these mismatched settings. Like at law school, you don't get an average premium of passing the bar if you're above the middle of your class. I think this may be because students who have really high credentials are just, are really nailing their STEM courses. Here's an example of this operating in medical school, where minority students who have a particular level of kind of pre-medical qualifications are ending up getting board certified at much lower rates than whites who have similar credentials. And this is an example of sort of a mismatch type effect in employment. This is looking at law firms. And I'm only looking at whites here. So I'm sort of getting rid of the race diversity altogether just to see how does this operate within whites. And dividing students who graduated from the University of Michigan into 10 deciles based on their GPA. Because one of the responses to my early mismatch work was that, why is Sander making such a big deal about grades? What do they really have to do with career success? And what this is showing is that if you're in the bottom decile and you start working for a law firm, what's the likelihood that you're going to be there 15 years later and make partner? It's only 4% for the University of Michigan grads. Whereas if you had high grades, you had, 6 to 8 times a higher chance of still being there 15 years later. So there are powerful effects in the labor force based on what's happening. It actually matters how you're doing in college for your later outcomes. Maybe, is that heartening or frightening? This is looking at socioeconomic diversity. So if you divide the American population into quartiles based on their socioeconomic status, their parents' education, income, and occupation, what you find is that law schools are very heavily tilted towards very elite students. So, an 82-to-1 disparity in this case between relatively privileged students and relatively disadvantaged students. So the policies that we're pursuing are not doing a good job of capturing socioeconomic diversity, certainly. This is really elaborating on that point. One of the implications of all of this is that African Americans with a given level of credentials in high school are more likely to go to four-year colleges than white students, whereas low SES students are about 70% less likely than affluent students to attend a four-year college. So there's a pretty clear imbalance in college admissions policies between race and socioeconomic status. This is making a pretty similar point. This is a different point, which is that part of the reason why we have these imbalances is that we're not doing a very good job of outreach. We're not finding talent that's out there. So this is looking at the proportion of SAT scorers who did well and even submitted an application to a really elite undergraduate college. So you can see those percentages are pretty high up here, but for low SES students, they're very low if you're not Asian American. One reason why Asian Americans are so highly represented at elite colleges is because even low SES Asian parents have a very strong orientation towards getting their students into strong schools. And that produces this really high uptake rate that really doesn't exist in the other racial groups. All right. What happens if the Supreme Court gets rid of preferences? Well, I think there are two different sort of paths that we might see. The great story is what happened at the University of California, my university, for about 10 years after California voters adopted Prop 209 in 1996. So Prop 209, if you haven't heard about it, was the first statewide measure, the first statewide ballot measure that passed and prohibited the state from taking race into account in granting preferences for state programs. So it covered state universities like UC. And what we saw over the next 10 years was a remarkable series of positive effects. I'm going to illustrate a few of those. At my law school, we adopted a new program to try to shift preferences from race to socioeconomic status. We found we could use much smaller preferences and end up with a class that almost exactly mirrored the US population. You saw those really skewed percentages I showed you before. We admitted a class that was roughly 25% of our students coming from each quartile. But we were able to use relatively small preferences to do that. We did some of that outreach. We sort of addressed all those problems I was talking about before. And we produced a class that had the highest bar passage rate in the school's history. UC didn't quite go all in that way, but they did launch a whole bunch of programs to improve their outreach. And what's striking here, if you look at the African American row, you see that in the 8 years before Prop 209 passed, there's really no change in the number of blacks applying to the University of California. It was like the university wasn't doing any outreach. They were just kind of using the preferences to get the racial balances they wanted. But after Prop 209 passed, they dramatically changed that, and they started doing all sorts of outreach to try to find those diamonds in the rough, and produced massive increases in Black and Hispanic applications. Much larger increases for these groups than for the other groups. There was also kind of a statewide focus on high school. UC helped with that. UCLA, for example, adopted a couple of Central City Los Angeles schools and invested resources in trying to improve graduation rates. And over the 10 years after Prop 209, you saw a big jump in Black and Hispanic graduation rates. So you were expanding the pool. Again, you're sort of, you're kind of denying a school the ability to take the easy path of racial preferences. And so they start doing the harder work of fixing the pipeline, at least in my view. Freshman enrollment goes up. Again, goes up especially for Hispanics, goes up pretty well for African Americans. There's an initial drop, and then those increased application numbers start producing higher enrollment numbers. What's really striking is that for the African Americans and Hispanics going to UC, we saw many, many more graduating in 4 years, many, many more having STEM majors. The overall graduation percentage goes up, and GPAs go up. So you're not only increasing the numbers, but having much, much smaller disparities in minority outcomes from white and Asian outcomes. This warming effect was kind of a surprise to everyone. A lot of people said, well, we need to have racial preferences because minority students won't want to come to a campus where their numbers are falling. That's called the chilling effect. And it turned out that there was actually the opposite effect, what I call the warming effect, which is that the take-up rate, the rate at which students admitted to Berkeley, UCLA, and UC San Diego, actually went up for Blacks and Hispanics pretty dramatically after Prop 209. We're not sure why. We didn't do any survey research to figure out what people were thinking, but the inference from a lot of indirect data is that students thought their degrees would be more valuable if they went to a school, if they went to Berkeley instead of Stanford, they could say, well, I got into Berkeley clearly on the merits. There was no special treatment involved here. And that was appealing to students. However, after about 2006, UC started backing off of this regime and started reintroducing racial preferences. And I really blame UC administrators because there was always kind of a student protest about the existence of Prop 209, complaints about diversity falling on this campus or that campus. Media coverage tended to focus on drop in black enrollment for first-year students at UCLA and Berkeley, and the media tended to ignore all the positive effects that I've just talked about. And the administrators just kind of went along with that story. They encouraged the story instead of pushing back and saying, no, actually this is having surprisingly positive effects. So in 2007, UCLA reintroduced racial preferences. They didn't admit they were doing it, but the evidence is quite overwhelming. And no one sued, and the other campuses started doing the same thing. So over the last 10 years, we've really seen, I think, almost a disappearance of compliance with Prop 209 at the University of California. This is an example of what UCLA did. This is that first year, and this is a study by Robert Mayer, a leading sociologist at UCLA, who was actually retained by the university to do this study. I was only able to get a copy of it through a Freedom of Information Act request. And it found that when you took into account everything, you got a certain emissions profile, and then with the race effect, you had this net effect on North Asian American applicants, small effect on whites, big increases for blacks and Latinos. 4 years later, it was even more significant. This is recent data from a website where college seniors report the outcomes of their law school applications. And students will say, I have these credentials, I got into the following schools. And if you scrape that data and put it into a regression, you find that the LSAT gap between blacks and whites who are admitted to these different colleges are these numbers here. These are all colleges that are not covered by any sort of state ban on preferences. 10 points is a pretty typical preference size. These are colleges that are covered. My school looks like the most law-abiding of them all, but most of the schools, all the schools are using racial preferences to some degree or other. So now I'm going to move to sort of, very briefly, just kind of some environmental effects of all this. One environmental effect is that there's less and less transparency in higher education. I've been working on these topics for about 20 years, and each year I find more pushback, more hostility and resistance of universities to releasing information. They really don't like you seeing slides like this. They don't want people to know how admissions are working, so they suppress the information. But there are ways to, as we've seen, increase diversity without using preferences. It's important that we focus not on first-year enrollment, but on actual outcomes. In law, everyone is focused on trying to have 8 to 9% of first-year admittees in law schools be African American and X% be Hispanic. And everyone ignores the fact that for the last 40 years, the proportion of African American lawyers has been stuck at 5%. That difference between 8.5% first-year law students and 5% lawyers is mostly due to mismatch. That's a scandal, and it suggests that schools are looking at the wrong thing. They're focused on the wrong kind of diversity. Something I've been suggesting at UCLA that I think would work, be a model in a lot of places, is to offer courses say, a law class at Cal State LA, you'd have mostly minority enrollment, and say, we're going to teach a first-year property class. And if you get an A in that class, regardless of your LSAT score, you're automatically admitted to UCLA. You'd be doing a better job than using the LSAT in finding talent. You'd be admitting students who would succeed, and you'd be increasing diversity. So there are lots of ways to do this if you just sort of make it harder to do the easy thing. Only 3 slides left. The other big environmental thing that I'm concerned about is just sort of the increasing censorship of ideas in the academy. And one of the things that's wonderful about CMC is the degree to which you have intellectual diversity, and you're able to have events like this. That's becoming rarer in the academy. I'm going to give you 3 examples. So at the University of Pittsburgh, Norman Wang is a very respected cardiologist. He was a senior administrator at the medical school. He published an article about mismatch in medical schools and the operation of affirmative action. And it sort of went through all the peer review. It got published in an elite journal. And then social media got a hold of it. The journal abruptly retracted the article. I'm not sure what that means if you retract something that's already published, but they were disassociating themselves from the article. They didn't say there was anything wrong with it. They just didn't want to have their name connected with it. And Wang was fired from his administrative positions. Not for saying anything that was incorrect, just for saying something that was politically incorrect. At the University of California, I got extensive data in 2008, shared it with a wide range of colleagues who did various types of research on it. Some of the research was on mismatch and found the kind of effects that I've been talking about. Now the University of California not only won't provide updates to that data, but they've given data to a sympathetic researcher, someone who's ideologically sympathetic, on the condition that he won't share it with anyone else. So you now have research being produced in this field that's not shareable, that no one can check the results of. And finally, Georgetown, you may have heard the case of Sandra Sellers, who was an adjunct professor who taught a class on Zoom. After the class was over, but while the recording was still going on, she was talking with a colleague about her frustration with racial disparities in performance she was observing, which, as I've said, have actually nothing to do with race. It's just a function of the admissions policies that you can see at Georgetown. So she said this, someone found it, and she was fired. Maybe even more disturbingly, the person she said it to, who was just sort of listening and saying, was suspended. So if we were doing this talk at Georgetown, you would all be in big trouble right now. Anyway, that's it. Thank you.
Thank you. Thank you to Professor Sonder for that presentation. We will now proceed to dinner. Please allow for the speaker and the head table to approach the buffet and follow shortly after them. Thank you. We will now transition to Q&A. If you'd like to ask a question, we ask that you come up to one of these 2 mics, give your name, major, class year, and try to limit to 1 question. Thank you so much.
Hi, my name is Nick Agrawal. I'm a junior at CMC majoring in philosophy, politics, economics. Thank you so much for your talk. So my question is, in Groder v. Bollinger, the court ruled that there is a compelling state interest in obtaining the educational benefits that flow from a diverse student body. Do you think that those benefits are legitimate? And if so, do you believe that they represent a compelling state interest which would justify the use of racial preferences under the strict scrutiny standard? Thank you.
Good question. So the Grutter decision was predicated, it sort of said, okay, we get that there's a compelling state interest here. So you can use preferences if they're narrowly tailored. And narrow tailoring means trying to use them in the most constricted way possible. And I talked about some examples of that, right? And a lot of what the justices were saying in the oral argument was that we don't think you guys are trying to narrowly tailor at all. Preferences are still really large. They haven't diminished over time. We've been doing this for decades. You're not really using socioeconomic status aggressively. You're not limiting legacy preferences. So I think the court is continuing to recognize that there could be a compelling interest, but they basically are no longer believing that the universities are willing to narrowly tailor their use.
Thank you.
Yep. Hi.
Thank you. So I think one thing that a lot of folks, when they hear these kinds of arguments, think is because a lot of the folks who make these arguments are sort of against the idea that education institutions should be explicitly pursuing racial justice. But it seemed to me from your talk and from the point about mismatch that's not how you feel. You feel that affirmative action is just a blunt instrument to do that. So can you elaborate a little bit more on what you think the goals of affirmative action should be, what you think the role of higher ed institutions can be in fighting racism?
Great. So affirmative action started in the 60s as an idea of trying to break down barriers of entry. So in the Kennedy and Johnson administrations, a lot of what the federal government did is it tried to stop using old boy networks to recruit people. It said, let's move to more objective criteria. Let's do more recruitment at historically black institutions. Let's figure out ways to open the passive opportunity. The preferences came in around the end of the 1960s. And I think the rationale for the preferences originally was, well, this sort of opening doors may eventually work, but it's taking too long. We need to speed up the process. And preferences as originally envisioned, I think, were seen as maybe a 10 to 15-year process. In fact, there's language in the Bakke decision that, people's confidence that people would write a amicus brief saying, by 1988, these will be gone. So it was seen as sort of a necessary evil for a transitory period. But once schools were into that system, it became impossible for very, very difficult for any school to be sort of a first mover and say, well, this hasn't worked out so well, so we're going to phase out the preferences, or we think the transitory period is over. There was just incredible pressure to maintain the level of diversity that had been achieved only through preferences. And while in the 60s and 70s, you saw a pretty significant shrinkage in racial test score gaps, and you saw, a really substantial increase in the black and Hispanic middle class. But around 1990, that seemed to stop translating. Those trends seemed to stop. I think partly because of mismatch, frankly. And so you no longer sort of have the justification that, well, this temporary measure is producing visible results. The size of the preferences hasn't changed at all since 1990. So where does that leave me? So the point is that, the argument that this was a way of effectively achieving racial justice didn't work. To me, I've mentioned some things that I think you could do to preserve diversity at schools and increase socioeconomic diversity. But the real action is fixing the pipeline. And an example of a dramatic thing we could do to fix the pipeline is to reduce housing segregation. I've actually done a lot more work on housing segregation than on affirmative action. But nobody reads it, so there you go. But if you look at cities that have made significant progress in housing desegregation, you see remarkable levels of racial progress. So there's a big black-white gap in mortality in America, for example. Black life expectancy is lower than white life expectancy. In cities that are relatively integrated, the black-white gap in mortality is 2/3 smaller than it is in cities that are highly segregated. Just think about that. I mean, if that's true, that's just telling us all sorts of things, and it lays out a really obvious policy roadmap. All racial gaps are smaller in cities that have achieved lower segregation. So focus on that. Do things to reduce segregation, and then you won't need, or at least you'll be in a situation where much smaller racial preferences would get you much larger benefits. Yeah.
Thank you so much for your talk, Professor Sander. My name's Henry Long. I'm a sophomore here. We talked earlier.
You look familiar.
For the podcast. Your talk seems to suggest that affirmative action is not an effective method for mitigating racial disparities in education. Might there be other legitimate purposes for which affirmative action could be used, setting aside the question of whether it actually mitigates racial preference or racial discrepancies in education?
Well, again, I want to distinguish between affirmative action and racial preferences, right? Affirmative action involves all sorts of affirmative things we can do other than having different standards that vary by race, right? Like reducing segregation or providing academic support or improving outreach. So I guess you're asking, are there contexts in which racial preferences would be good? And I think an example would go to the housing segregation case. I would like to see us have programs where we provide incentives, mortgage interest incentives, rental incentives that reward people who make pro-integrative moves. So if a person of any race moves into a neighborhood where their group is, say, less than 5% of the neighborhood population, let's give them a mortgage subsidy or a rental subsidy. If you did that and you had counseling programs telling people about that, you would pretty quickly reduce levels of segregation.
Thank you.
I think we need to build a pipeline here.
Good evening. I'm Linda Perkins, and I'm a professor at Claremont Graduate University.
Hi.
I wanted to ask you, there was a study about 20 years ago by the presidents of Princeton and Harvard, Derek Bach and
Yeah.
William Bowen, Shape of the River, and it talks about
They're
the
both friends of mine.
long-term
Well, I don't know if they would
consequences.
consider me a friend, but
Long-term consequences, and they said exactly the opposite of what you just said in your talk. And it showed how successful Black students had been, even with reduced grades and all of the rest, that they were extremely successful. So the criteria just of scores, whereas these institutions did take a more holistic approach to these students, taking in consideration these other things, the results were positive.
so the Bowen and Bach study, this is The Shape of the River, which was published in 1998. It did valuably document a lot of what had happened in affirmative action. Part of why they found some positive results is that they were looking at the very early period. So they were comparing class of 1973 with class of 1993, for example. And that was a period where I think affirmative action was having some positive effects. But the big thing is that Bowen and Bach never actually measured mismatch. They never explicitly talked about that as an issue. They were just sort of talking about, has the general increase in access of minorities to higher education, especially the Ivy League, had positive effects? And it was clearly having some positive effects during those decades. But that slide that I showed you about the STEM majors, the ones where you had the very high attrition rates depending on how mismatched you were, they never did any analysis like that. That analysis is with their data. The person who did that is the only person who has been able to get access to their data who was sort of interested in taking I would say, an open-minded perspective to the issue. They have been very restrictive about they haven't let me access the data, for example. So they've generally sort of had a political test on who can use it. But these two researchers somehow passed the test. They measured mismatch, and they found these very strong mismatch effects. So I think that well, what the data showed is that when there were lots of, there were many more blacks getting, PhDs in the sciences in the 90s than there were in the 60s. That's evidence that something positive happened. But the point is that if you actually look specifically at the mismatch issue, if you looked at what happened to those students who got large preferences, as opposed to those students who were admitted because of other aspects of affirmative action like better outreach, those students were being devastated.
Hi, thank you so much for coming to speak to us tonight. Really interesting talk. I was thinking a little bit related to the previous question about how, yes, like metrics like standardized test scores and outcomes or grades are really important, but there are also a lot of other, particularly in like undergraduate institutions, opportunities that come with going to a more elite school, such as networking opportunities, prestigious clubs. And in her concurring opinion to Grutter v. Bollinger, Justice Ginsburg said that a lot of her opinion on that issue was related to the idea of remedying a legacy of discrimination, particularly against Black Americans. I'm curious if you see your argument as claiming that there is affirmative action isn't critical to fighting that history or that legacy of discrimination, especially considering like the other opportunities that exist at higher education institutions.
Okay, well, I think there are two questions there. One is, again, not affirmative action, but racial preferences. Are racial preferences helpful in overcoming that legacy? And I think what I'm saying is that pretty overwhelming amount of evidence suggests that large preferences of any kind are going to be counterproductive to whatever your goal is. So that's not an effective strategy, and we need to have more candor by higher education officials to recognize that and to provide data. If they disagree, then provide the data and let people analyze it. That's really my argument there. Broader affirmative action issue goes to things like what I've talked about with housing segregation. Yeah, we need to recognize that we have racial disparities, and we need to try to figure out what are things that have been tried that are clearly having a direct impact. Desegregation has a huge, an unbelievably large impact. So let's focus efforts on that. So partly from the urging of the cohort of scholars I work with on housing segregation, the Department of Housing and Urban Development is actually issuing regulations this year to try to nudge cities a little bit towards being more proactive on housing segregation. But the amount of social and political capital that goes into that is tiny compared to the amount that we're investing in admissions preferences. And this clearly, there's any scholar who disagrees that this is enormously effective. And there are a shrinking number of scholars who think this is effective. So our priorities are really mixed up.
Thank you.
Thank you.
Hi, my question is about the metrics that you use to determine matching, because I have definitely in the last year been a part of a lot of conversations at CMC where if people don't feel maybe matched with the institution, it has a lot to do with the fact that the institution isn't doing things that validate their experience and at the institution. And there's really structural forms of racism even within the infrastructure of these kind of elite institutions. So given that, what would you say about a critique to your matching metrics, in that it's actually the institution that is not doing enough to help people who don't feel at home at their institutions?
Mm-hmm. Good. Yeah, so I was discussing over dinner how I got into all this because in the 90s, when I started at UCLA, I was recruited to help evaluate academic support programs we had. And we had 7 different types of academic support operating at UCLA. And we figured out ways to systematically evaluate them. And we found that 5 of the programs were ineffective. 2 of the programs worked. And we persuaded the law schools to get rid of the 5 and invest more in the 2. So there are definitely ways you can make progress with academic support. But the degree to which the academic support could overcome the effect of a large preference was relatively small. You can maybe overcome about 1/4 of the GPA gap and maybe 10% of the bar passage gap. So it wasn't enough. And we were putting a lot of resources, a lot of faculty energy into trying to do this. So that made me pessimistic about whether this could solve the entire problem. Now, the other thing I think you're asking about is whether the credentials themselves are sort of biased. And as I said, I think we ought to find better new pathways, additional pathways, like my idea of teaching a law course at Cal State LA. That's a way of identifying the diamonds in the rough, right? But the research very consistently shows that standardized tests and GPA measures do not underpredict Black and Hispanic performance. They predict performance of all groups pretty much the same way. So that's indicating that these measures are not biased. The disparities that they're capturing are real disparities in learning and educational preparation. So the movement, I mean, I predict if the court rules against preferences, we're going to see even more schools abandon things like the SAT. I think that's exactly the wrong thing, because you're sort of striking your eyes out in the hope that that random admissions are going to increase diversity, but it's actually going to increase mismatch.
Thank you.
Hi.
Yeah, Dr. Sander, thank you for this. I'm sorry I only caught the last 15 minutes. I was teaching a class over at the Graduate University. I'm also a faculty member over there. I'm also an affirmative action baby. So I was the first Chicano to go to the Ivies out of Stockton, California in 1976. And the PhD is from Duke after working at Stanford. So I've been around these conversations for quite a while. I'm curious if in the metrics we have the variable of generational capital laid out. So do we know of the white students, their parents, their grandparents, did they go to that school? Because that was certainly my experience at Yale when my roommates' grandparents had a room together. And I love the idea about creating pipelines at the Cal States, because that's where the bulk of Latino students are in California. That'd be very meaningful. But I'm very pessimistic about what we're facing with the decision. But I do see something in the legacy of W.B. Du Bois, who in 1903 told the Black community, there's 1,200 lynchings this year, but there are also 1,200 students in the historically Black colleges and universities. And there were 1,200 graduates that year in the last 10 years. So a visionary like that told the Black community, let's nurture the talented 10th. And they built that structure. He mentored Benjamin Mays, the great sociologist from Chicago, who then took the helm of Morehouse College in 1940, just in time for a young freshman by the name of Martin Luther King Jr. So whatever we're facing in terms of the decisions that the Supreme Court makes, I think we're going back to a moment like that, where we're going to have to look to the community to provide those variables of inspiration, of motivation, of structure that the Black church gave to the Black community in a pre-affirmative action period, because the way politics have gone, I see affirmative action going away, but I do see at this moment in history we have enough in the community now to just get the kids through places like CMC, regardless of what the, I think, limited metrics say, because I don't find myself in the metrics. I dropped out. I was an academic withdrawal from Yale. My dad died. Things went to pot here back home, but I did what I had to do, and I got back and I finished, and I had a successful end of the career. So where in the data, besides the box study, do we track someone like me, who is now at the apex of his higher education career? How can we think about putting those variables in generational motivation, legacy, social capital, all of that sort of thing? Thank you very much.
Yeah, good. We don't do it the way we're doing it now. So at Harvard, Harvard Law School, someone did an unusual analysis where they actually sort of explored the background of Black students in Harvard Law School. And they found that 70% of the Black students were either multiracial or foreign nationals. Only 30% had 4 Black American grandparents. So we were doing a really poor job of, I think, identifying people who had actually experienced disadvantage through the American racial system. with socioeconomic metrics, you can do a much better job. I mean, the socioeconomic system I introduced at UCLA asked about family wealth. You know, disparities in wealth correlate strongly with race, but they correlate even more strongly with an absence of family wealth and disadvantage for your grandparents and things like that. So we can use more direct measures. And I think if you sort of step on the part of the balloon that allows racial preferences, it expands the part that's looking at better ways of trying to really identify disadvantage and remedy it.
Excuse me. I suppose my question is that you mentioned that within the UCs, by ending racial preference, they were then compelled or forced, in a sense, to then take measures through outreach programs to still fulfill their desire for diversity.
Right.
I suppose my question would be then, do you think that is possible in states that don't have the same educational infrastructure as California, given that California's junior college system, as well as programs such as the TAG program, and for anyone who doesn't know the TAG program, if you have meet certain grade requirements at junior colleges in California within certain majors, then you're guaranteed admission to UCs, as well as California, just the Cal State and UC system being something that's not really comparable to any other college system in America. Do you think that other states would be able to have as much success in outreach should racial preference be ended?
Good, yep. Fair enough. So there have been 10 states that have done something like Prop 209. And Richard Kohlenberg, who was, he's a good friend. He was the plaintiff's expert on race-neutral remedies in the Harvard and UNC cases. And he was the subject of a full-page New York Times profile last week. He did an analysis and found that in 8 of the 10 states, the university systems did respond, substantially increased socioeconomic diversity in response to the bans on race. Yeah, so I think California is a bit of an outlier. We wouldn't expect every state to be as aggressive as UC was after Prop 209. But it looks like the vast majority of states and state university systems do care about diversity in a genuine way, and they're not going to take the ban as an excuse for inaction. They're going to be serious. They're going to explore alternatives. The other thing that he found is that in all 10 states, the state universities got rid of legacy preferences. As soon as you couldn't use racial preferences, the legitimacy of legacy preferences in state universities was completely untenable. So they all went away. I think that was a good step. And my wife, the brief writer, thinks it was a good step too.
Thank you to Professor Sonder for his presentation. Thank you to the audience for your questions. We hope to see you again at the AF soon. Have a good night.
Thank you.